Let's talk about Tornetta versus Musk and where it came from and what we can possibly expect moving forward. So, a judge has again rejected, this is now the second time, the compensation package for Elon Musk that was supposed to be sent to him from Tesla. It was going to be more than $50 billion at the time that the judge had rejected it. And this was really a victory to the shareholder who opposed this pay amount. Let's back up first. Why did Tesla create such an unorthodox compensation deal for its CEO? Well, we have to go back to 2018, and this is when Tesla shareholders approved a 10-year performance-based pay package for Musk. And, we all know Elon Musk has his hand in all sorts of different things, and Tesla was kind of worried that he was losing focus, or he would lose focus, and he wasn't completely 100% dedicated to this one project. So Tesla said that the pay plan was structured in a way that would reward him with really lucrative stock options if the company hit certain growth targets over the course of the decade. And when the deal was approved by the shareholders, many people said that the targets were ambitious, to put it lightly, or even unbelievable, and there's no way that they could be reached. For example, they included developing a prototype for the Model X SUV and growing the company's market capitalization to $650 billion, which would be more than 10 times what the company was worth back at the time. So, ahead of the 2018 vote, Tesla's board said that the growth milestones were, in fact, designed to be difficult to achieve, and therefore the rewards were lucrative in order to reflect that challenge, right? It's like the carrot in front of the stick. A quote from a letter that the directors wrote to the shareholders in 2018 says, quote, "Our aspirations may appear ambitious to some and impossible to others, and that is by design." So back then in 2018, many people thought it was crazy to think that Musk would even hit any of these targets that were laid out in the plan. And the package for compensation effectively required him to supercharge Tesla's valuation more than 10 times over. Well, fast forward to 2022, and Musk hit all of the targets. He hit the last of the targets in 2022, and this would have granted him options to purchase over 300 million shares of Tesla. The options exercise price was tied to the value of Tesla's shares on January 19th of 2018, and that was around $23 after the stock splits. And since then, Tesla's share price has surged to over $300 a share. So that led to Musk's award gaining billions of dollars in value. Now, he has not exercised any of these options up to this point. So the compensation package would have made Elon Musk the highest paid executive ever. And again, the board members said pretty much openly at trial that their concern was that he was being drawn away from Tesla to pursue other endeavors. I don't know, put a man in Mars, take over the government bureaucracy, do all these different things. And they wanted to really give him the incentive to stay with and grow Tesla. Now, not everybody on the board felt the same way, though. And that's where we introduce Richard Tornetta. He is the Tesla shareholder who filed this lawsuit. So he objected to the compensation package and filed this lawsuit against Musk and Tesla in 2018. In the lawsuit, Tornetta alleged that Musk exercised outsized influence with the board as it was drafting this compensation plan, and that the investors were misled when they were asked to approve it. In fact, he accused the board members of Tesla of failing to exercise independence as they were putting together the pay package for Musk in 2018, and basically saying there were a bunch of pushovers who allowed him to improperly engineer the details of his pay plan to his liking. Now, Tesla responded to this, and they said, quote, "For each of the remaining 11 milestones, Tesla's market cap must continue to increase in additional $50 billion increments. Thus, for Elon to fully vest in the award, Tesla's market cap must increase to $650 billion. End quote. That's what they said. They're like, no, he's not exercising undue influence. This is not a sweet deal that we're just giving away, the whole farm to him. He's got to really make this company go on fire here. He's got to really pump it up. And guess what? Today, Tesla as a company is valued at over $1 trillion. So they're basically saying, look, he did this. He's entitled to his compensation. So this brings us to the question, why did the judge originally rule against Tesla? As I said, what was just decided was a second ruling against Tesla. So first we have to back up and talk about the first one. So this was a decision from the Court of Chancery of the state of Delaware, state court in Delaware. Delaware has many, many LLCs registered in the state of Delaware for numerous reasons. Delaware has kind of become the commercial capital of the United States, where people incorporate corporations there. There are certain tax benefits of doing so, etc. We're not going to go into all of that, but for our purposes, we have to know that Torrenta, as well as the other similarly situated people who were not happy on the Tesla board, filed this complaint against Musk in this state court of Delaware. Okay, and the judge was Delaware Court of Chancery Chancellor Kathleen McCormick. And so in her initial ruling in January, McCormick basically ripped up this compensation package. And she called the process surrounding its creation, quote unquote, deeply flawed. Almost like an unconscionability type of procedural unconscionability type of argument. She didn't use those words, but that's kind of how I understood it. She said that the board members failed to act independently in negotiating the pay deal. She wrote, quote, "In fact, there is barely any evidence of negotiations at all." And she also called the size of the reward itself, now talk about like more substantive unconscionability. She said the size of his compensation was, quote, "an unfathomable sum," and that the record-setting amount was just an unfair price to award a CEO, even Elon Musk. So after she ruled this way, Tesla decided to hold a second shareholder vote in June. So her ruling came out in January. Now we're in June. And the shareholders are going to vote on Musk's pay. Okay? So there were proxy filings ahead of that vote. And with those, Tesla attaches Judge McCormick's 200-page opinion that struck down the compensation package. And this was clearly an attempt to address her criticism that the shareholders did not have all the information ahead of the first vote. And so lawyers representing Tesla in this suit come back to court and they say, look, 72% of the voting shareholders supported Elon Musk's pay package despite all of these court objections, despite this 200-page ruling. And Tesla says that this shows that the process is, quote, "one of the most well-informed stockholder votes in Delaware history." So this goes back to the court, and the judge is not impressed. So she comes out with now this week an additional ruling that's about 100 pages and said, "I'm sorry, but..." Well, she didn't say sorry, kind of sorry, but not sorry, that this still was a problem. She said that Musk and his attorneys have, quote, "no procedural ground for flipping her previous decision from January, and she again strikes down his pay package. She says that there were, quote, multiple material misstatements about her original ruling in Tesla's proxy filing. And she says that those alone would have rendered the second vote insignificant or insufficient as a means of overturning her original judgment. So it's actually kind of a interesting legal strategy, or a bizarre legal strategy, that the defendants kind of thought that they could just fix the original problems that she laid out in her 200-page decision by literally just having the shareholders vote again on the same package and just showing them that decision. And, it comes back to the court, and the judge is like, no, that's not good enough. Like, you can't do that. So she said that a stockholder vote standing alone cannot ratify a conflicted controller transaction. That's in her opinion. And what she means by a conflicted controller transaction is that she feels that there's a conflict of interest that Musk played in these negotiations, being, the head of the company and kind of putting this pressure on the shareholders to kind of give him whatever he was looking for. She says, in the opinion, quote, there were undoubtedly a range of healthy amounts that the board could have decided to pay Musk, right? Instead, she said the board capitulated to Musk's terms. So she's just looking at the record and saying nothing in the record here shows that there was any real give and take, any real negotiation. It was just he laid out the terms he wanted, and the board said, okay, great. And she said from a procedural perspective, that doesn't suffice. She said that there were no new negotiations that took place at all before Tesla resubmitted Musk's proposed pay deal to the stockholders in June. And she really did not like that. She also said, really interesting for our purposes, that no Delaware court has ever reversed its judgment based on this kind of action, based on a stockholder vote that just takes place after a trial. And she also noted that if companies could do this, if they could literally just kind of create new facts after judgments were reached by courts, that quote unquote lawsuits would become interminable. And that just means a fancy term for endless. Like, whenever a lawsuit is decided in a favor that doesn't go with a company, the company could theoretically take this as precedent and say, oh, well, we'll just vote that, we are okay with, whatever the court said that they were not okay with. And she said that obviously would open up the floodgates and would make the judges' jobs too busy. What's interesting is that not only did the judge strike down the compensation plan for the second time on Monday of this week, she also awarded Tornetta, the plaintiff, $345 million for legal fees. And she said that these could be paid with either cash or Tesla shares. Actually, the plaintiffs, led by him, asked for $5.6 billion in legal fees. And, the judge said she used the term a bold ask. But I guess she felt that $345 million was not bold and appropriate. So the question is now, what will happen next? Musk is unhappy with this, as you can imagine. He's just trying to get paid for the work that he did. He felt like he provided services to the company that made this company worth what it is today, and he should be awarded for doing that. And there was an incentive to do it, and he was able to do it. He went on X, formerly known as Twitter, until he bought it. And he said on X that shareholders should control company votes, not judges. Tesla also published a response where they said this ruling, if not overturned, means that judges and plaintiffs' lawyers run Delaware companies rather than their rightful owners, the shareholders. What's interesting to note from a procedural perspective, talking about civil litigation and federalism, is that unlike the US Supreme Court, which gets to choose which cases to accept jurisdiction over on the appellate level to hear, they don't hear most of the cases that come before them. They don't even, consider them. But Delaware's top court actually has to accept any appeals from the lower court decisions. So this will get to the Delaware Supreme Court. So let's recap, for example, where this leaves us and where we are headed. Tesla shareholders now have voted twice to give their CEO, Elon Musk, this compensation package. The compensation package is currently valued at more than $50 billion. That would make him the highest paid executive ever. And that was tied to the performance goals of Tesla. It kind of parallels the success of the company under his leadership. Now, for the second time, this Delaware judge just ruled that they cannot do this. Tesla said very clearly, we are going to appeal this ruling. And that would send the decision straight to the Delaware Supreme Court. And the Supreme Court there would have to take it, unlike the U.S. Supreme Court, which could just say, sorry, we're going to deal with other issues. We're not going to take this case. So the Delaware Supreme Court has to take it. And that court would revisit both the January ruling of an improper process for setting the pay package, as well as the decision from earlier this week regarding the failure to fix those problems with the shareholders just voting again after being presented with the 101-page decision from January. Another wrinkle here is that since these proceedings began, Musk actually relocated his company to Austin, Texas. So how does that play out, right? Does Delaware still have jurisdiction? Does Texas have jurisdiction? Is this now a federal question because it's an interplay of states where, how does this play out? Well, nobody's 100% sure, but what it means is that potential litigation of this new pay package would probably now be able to make its way through the Texas state courts as well. And now I know you're thinking, could this even reach the United States Supreme Court? Well, I think it's very likely that the answer is yes. This could set up a legal battle in 2025 that could go to the Supreme Court of the United States. And very simply, the U.S. Supreme Court could say this is a matter of significance to businesses across the country, CEO compensation packages of those businesses across the country, the well-being of the entire United States economy. They could look at this and say, Delaware is involved, Texas is involved. They could find some constitutional provisions from the United States Constitution that are implicated here. They can say that this, has some sort of effect on interstate commerce. I don't know, whatever they want to do. This is most likely going to the United States Supreme Court, and Musk is probably happy about that, especially after the election, right? Because Republicans are in control of the government. The Supreme Court recently has been friendly toward Trump and those type of policies. And this could be considered like a pro-business type of case in the way that Elon Musk has been framing it, right? That the companies should decide how they run their affairs and how they compensate their CEOs, not the Delaware court system. So this definitely could get to the courts, the United States Supreme Court, and could have implications for really any big publicly traded company. The novel question that's been at the heart of this fight is really a question that has implications all across the board in corporate law, which is, can shareholders ever overrule a judge? Right? The judge issued her original 101-page decision in January, and then Tesla's legal strategy was literally just to look at that decision, circulate the decision, and have the shareholders try to appeal that decision by reaffirming their commitment to the compensation plan. And that was back then when, in last August, when Tesla kind of decided on this legal strategy, there were predictions from legal scholars across the board that this was a bizarre legal strategy, just kind of having the board ratify the original agreement. I found quotes that said things like, Tesla's argument was that shareholders, not judges, should decide corporate transactions. Otherwise, the wider business world will lose faith that they can rely on the agreements they reach with their stockholders. And how corporate law attorneys were predicting back last August that that pitch just will not be enough to change this judge's decision. They said the question at the heart of the case could move ahead on appeal as far as the U.S. Supreme Court. So this was brewing for a long time. This strategy that Tesla chose in response to the original January decision was a decision on Tesla's part that kind of had legal scholars scratching their heads like, are you sure this is the way you want to go? This is unprecedented in Delaware law. And as we saw in the decision, the judge clearly said this has never been successful before, where a company just looks at a decision that says something and then says, no, we're going to ratify it anyway. That doesn't alleviate the underlying problems. So while this kind of brews throughout 2025 and goes through the Delaware Supreme Court, maybe courts in the state of Texas, and probably up to the United States Supreme Court, this could potentially affect a wide variety of other companies and how their CEOs are compensated. It's certainly going to be interesting to see how this plays out.